All right, what's your name? What are you doing
Sir,
over
what
here?
happened? Why you ask me?
You seem suspicious. That's enough for me to talk to you.
Talking is fine, but there is no legal reason for demanding my personal information.
If you keep playing games, I can take you to jail for obstruction.
This officer thought he found an easy target, but he just committed professional suicide. He didn't realize the man he was illegally detaining was a high-profile civil rights attorney who knew the law better than the chief of police. Watch the exact second his ego shattered when he finally understood his career was over. Where are you watching from? Drop your city or state in the comments. And if you like stories where cameras and the law expose bad policing, hit like and subscribe. Now back to it. Officer Travis Rourke already had Marcus Bennett in a detention outside a parking structure near the courthouse district. Close enough to box him in, loud enough to perform authority, confident enough to assume nobody would challenge him. Marcus didn't move much, hands visible, body still. He kept his voice controlled because he knew the game. If Rourke could trigger a reaction, he'd label it as resistance and turn the whole encounter into a justification. Marcus asked if he was being detained and what specific crime Rourke suspected. Straight to the point. Rourke didn't give a clear reason. He went with vague, suspicious talk and kept issuing commands like that alone was a legal basis. Marcus didn't argue emotions. He started building a record. He stated that he didn't consent to any search. He stated that Rourke had not articulated reasonable suspicion. He stated that he would comply with lawful orders while not answering investigative questions beyond what the law required. That's when Rourke's tone changed. He stepped closer, got sharper, tried to make Marcus feel small. He started hinting at arrest, using obstruction-style language. Without any real obstruction happening, it was pressure. That's all it was. Marcus stayed steady and kept documenting out loud for the camera. He framed what was happening as a Fourth Amendment seizure. He noted that extending a detention without a stated basis creates liability. He kept his words clean and specific because later this would matter more than anything Rourke was saying. Marcus then asked for Rourke's name and badge number. Rourke refused. That refusal wasn't a minor detail. It's the kind of decision that turns a bad stop into a deliberate one. And it's the kind of thing departments hate seeing on video because there's no innocent explanation for it. Marcus stated that the refusal to identify would be included in a formal complaint and any legal action that followed. No threats, just a fact. Here's what Rourke didn't understand yet. Marcus Bennett wasn't a random citizen trying to talk his way out. He was a civil rights attorney with a track record. The kind of attorney who sues departments for unlawful stops and retaliatory threats. The kind of attorney who knows exactly how these encounters get defended in court and how to cut those defenses off at the knees in real time. Marcus had been in the courthouse area for work, routine, normal day. Rourke didn't have a dispatch call, no matching suspect description, no report from a business owner, no victim pointing anyone out. He made the stop off a look and a feeling, then tried to force it into legality through dominance. He kept pushing for information Marcus didn't have to give. He hovered near Marcus's pockets and personal items like he wanted consent without asking for it. Marcus shut that down. He repeated that he didn't consent. He repeated that Rourke needed a lawful basis to continue. Short sentences, clear boundaries. Then Rourke made the mistake that changed everything. He moved toward Marcus's wallet area like he could just take control of Marcus's property and call it procedure. Marcus didn't yank away or make sudden moves. He stayed still and stated clearly that any seizure or search without probable cause or consent would be unlawful under the Fourth Amendment. He said it so the Bodycam would catch it. He said it so any reviewer would hear exactly what was being challenged. Rourke paused. Just a fraction. His confidence didn't disappear, but it cracked. Because now he was dealing with someone who wasn't guessing, wasn't scared, and wasn't speaking in generalities. Marcus told him he He would provide whatever identification the law required, but he would not answer investigative questions and would not consent to searches. Then Marcus mentioned he had professional credentials on him. Rourke brushed it off and kept posturing, but his rhythm was already changing. Rourke finally asked for Marcus's identification in a way that wasn't normal procedure. It wasn't calm. It was a power move. He wanted something he could hold over Marcus, something he could use to keep the stop alive. Marcus moved slow and deliberate, the way you do when an officer's already looking for a reason to claim sudden movement. He didn't hand over his whole wallet. He pulled out what he intended to show and kept his hands visible the entire time. That's when the body cam caught the shift. Rourke looked at the card. He looked again. You could see the mental recalculation happen. His face tightened, his shoulders dropped a little, and his voice changed. Not softer out of respect, softer out of worry. Because it wasn't just a name. It was a credential tied to a civil rights law firm. Bar information. Professional ID that made one thing obvious. This wasn't going to end with Marcus going home frustrated. This was going to end with paperwork, subpoenas, and depositions. Rourke tried to recover control fast. He started talking like the encounter had always been routine. He tried to backfill justification with vague, checking things out language. He kept the same stance, but the aggression drained out of it. The intimidation didn't hit the same anymore because now it looked like what it was. Posturing without cause. Marcus didn't press emotionally. He pressed procedurally. He restated that he was being detained without reasonable suspicion. He restated that Rourke had refused to identify himself. He restated that he did not consent to any search. He made sure the camera had it all in one clean sequence, like he was organizing evidence in real time. Rourke then made his second major mistake. Instead of ending it, he escalated again. He leaned on the "I can arrest you" angle, trying to force Marcus into compliance through fear. He implied obstruction again. He implied failure to cooperate. He kept fishing for something he could write down later to justify the stop. Marcus didn't give him anything. He didn't argue side issues. He didn't debate attitudes. He kept it tight. He asked for a supervisor, and Rourke resisted the idea at first. You could tell he didn't want someone else stepping into a scene he'd already contaminated. He wanted to control the narrative alone. Marcus stayed on the request. Supervisor. Now. A few minutes later, Sergeant Lila Grant arrived. Not rushing in like a hero, just walking into a mess and immediately reading the body language. Grant looked at Marcus first. Calm, still, hands visible. Then she looked at Rourke. Tight jaw, defensive stance, over-explaining before she even asked. Grant asked what the reasonable suspicion was. She didn't ask for vibes. She asked for the legal basis. Rourke gave a messy answer. He tried to frame it as suspicious behavior. Then he tried to frame it as matching something. Then he tried to frame it as refusing to answer. He bounced between reasons because none of them were solid, and every change made it worse. Grant asked if there was a call for service. There wasn't. Grant asked if there was a description from dispatch. There wasn't. Grant asked what specific crime he suspected at the time he initiated the stop. Rourke didn't have one that held up. Marcus took that opening and locked the record in. He stated that he had asked multiple times if he was being detained and for what crime, and Rourke never articulated reasonable suspicion. He stated that Rourke refused to provide name and badge number. He stated that Rourke threatened arrest, while refusing to provide a legal basis. He stated that the detention had extended beyond any permissible brief inquiry. Grant didn't look happy, not at Marcus, at the situation. She asked Rourke again for his identifying information to be provided. Rourke hesitated. Then he gave it, but it sounded forced. Like someone complying with a demand he couldn't dodge anymore. Marcus requested an incident number or call reference. He requested confirmation that Bodycam was active and would be preserved. He requested that any footage from nearby city cameras be retained as well. That last part mattered, because it told everyone on scene Marcus knew how evidence disappears when nobody asks early. Grant then did the thing Rourke should have done at the start. She ended the detention. No apology from Rourke. No accountability in the moment. Just an attempt to leave before the damage fully registered. Marcus didn't chase him. He didn't gloat. He didn't need to. He finished with one clear line that landed because it was accurate. He told them Rourke didn't stop a suspect. He created a liability. Grant separated the scene, released Marcus, and pulled Rourke aside. Not for a quiet coaching moment. For containment. Because now there was a supervisor who had heard the lack of reasonable suspicion with her own ears. A supervisor who had seen the refusal to identify. A supervisor who knew this wasn't defensible. And within hours, the second camera hit the internet. A local resident, Jenna Ortiz, had filmed from her porch when she heard the tone. Her clip showed the posture, the crowd spacing, the officer's proximity, and the moment the whole vibe shifted after Marcus's credential came out. By the time the department understood what was circulating, people weren't asking, "What happened?" They were asking, "What are you going to do about it?" The department tried to get ahead of it that night, not with accountability, with damage control. A watch commander flagged the porch video within hours because it was already picking up traction locally. Then the Bodycam request hit. Then people started tagging the department and the city. The clip didn't need context. You could see the posture and hear the escalation pattern. You could see that the reason came after the control. By the next morning, Internal Affairs didn't treat it like a routine complaint. IA opened a formal investigation immediately. They pulled Rourke's body cam, the supervisor's body cam, and whatever street and garage cameras were in range. They logged it. They locked it down. No, we'll review it when we can. They knew what this was. Because the problem wasn't one rude officer. It was how clean the violation looked. Marcus didn't wait around either. He did what he always did. He built the case while the adrenaline was still fresh and the timeline was still easy to prove. He documented the time and location. He documented the duration of the detention. He documented the requests he made for reasonable suspicion, identification, and supervisor response. He documented the refusal to provide badge information until a supervisor arrived. He documented the threats of arrest tied to his questions. He also sent preservation notices fast, not dramatic, practical. Preserve body cam, preserve dispatch logs, preserve CAD entries, preserve any city camera footage, preserve disciplinary history for the officer, preserve training records. That's how you stop the usual game where evidence can't be located 3 weeks later. By day 2, the city attorney's office was in the loop. They weren't thinking about feelings. They were thinking about exposure. Qualified immunity depends on a department being able to argue the officer's actions were reasonable under clearly established law. This wasn't gray. This wasn't split-second decision. This was an officer initiating a detention without articulable reasonable suspicion, escalating with threats, refusing to identify, and trying to turn basic questioning into a reason to arrest. That's the kind of set of facts that gets officers personally named in federal complaints. That's the kind of set of facts that turns a city into a checkbook. IA interviewed Sergeant Grant early. That mattered, because she arrived, asked for the legal basis, and got nothing usable. Her statements were going to match the video. No wiggle room. Then Internal Affairs interviewed Rourke. He tried the usual script. Officer safety, suspicious behavior, non-compliance. I was conducting an investigation. He tried to stack vague terms on top of each other until it sounded like procedure. Internal Affairs didn't accept it. They compared his words to the video and the timestamps. They compared his claimed reason to the lack of a call. They compared his escalation to Marcus's calm behavior. They compared his refusal to identify to policy. They compared the threats to training standards. Then, they pulled his history. Not because they needed it to prove this incident. They didn't. They pulled it because this kind of behavior rarely shows up for the first time on a day with multiple cameras. Within a week, the department took an unusual step. They didn't place him on the standard administrative leave cycle and let it sit. They removed him from duty and moved straight into termination proceedings. Fast. That speed tells you how bad the footage was. Departments don't move quickly unless they feel trapped by evidence. The termination packet hit multiple violations at once, and it wasn't vague. Unlawful detention without articulable reasonable suspicion, escalation inconsistent with de-escalation and professionalism policy, threatening arrest without probable cause and using arrest threats to compel speech, failure to identify properly when requested, and refusal to provide badge information until forced. Conduct unbecoming, including antagonistic posture and tone that escalated the encounter. Bodycam conduct issues connected to proximity and scene management, creating an appearance of intentional intimidation. Marcus's lawyers also framed it under federal civil rights exposure, Fourth Amendment seizure, retaliation angle, pattern evidence if applicable. The exact language depends on the filing, but the structure was clear. This wasn't a misunderstanding. This was a violation with documentation. Rourke tried to save himself through the union. He asked for the usual slow process. He pushed for reassignment. He pushed for counseling and retraining. He pushed for anything that didn't end in a firing. The department didn't bite because they didn't just see a complaint. They saw a future deposition where a lawyer plays the body cam and asks the chief why this officer was still employed after that footage existed. And then came the move that really ended him. The department forwarded the case to the state's peace officer standards body for decertification review. That's the gatekeeping layer. If they pull certification, you can't just hop to the next town and start over. That process isn't instant, but the recommendation itself is a public signal. The department believes this officer should never work as a cop again. Meanwhile, the public side got louder. Local advocates started requesting stop data and complaint data. Reporters asked for prior discipline. Community members posted their own stories. The department's social media comments turned into a scoreboard, and Marcus stayed quiet publicly. That's how you know it's serious. When a civil rights attorney doesn't perform for the internet, it usually means he's letting the filing speak. By the time the termination became official, the question wasn't whether Rourke messed up. It was how the department ever let him work the street like that in the first place. By the time the city tried to calm everyone down, it was already too late. The video had done what statements can't do. It showed the sequence. It showed the control first and the justification later. It showed an officer trying to create a reason while a calm citizen kept asking for the one thing that matters, lawful grounds, and Marcus didn't let it drag out. He filed fast. Clean timeline, clear allegations. Fourth Amendment unlawful detention. Retaliatory threats tied to protected speech. Policy failures shown on camera. Supervisor confirmation that no real basis existed. Multiple angles of footage. Preservation notices already sent. Dispatch and catalogs already requested. The city attorney's office reviewed it and saw the same problem IA saw. They weren't defending a close call. They were defending a recorded violation. So they moved into settlement posture early. Not because they wanted to do the right thing, because trial discovery would be worse. Depositions would be worse. A jury would see the same body cam the public saw. And Marcus was the exact person who'd know how to make that footage look even worse in court. That's why the settlement got finalized this week. It was big. Not just because Marcus was a high-profile attorney, but because the evidence was strong and the city's defenses were weak. The agreement covered damages for the unlawful detention, attorney's fees, and additional compensation tied to the retaliatory threats and the refusal to identify. It also included non-monetary terms the city didn't want to negotiate in public, but couldn't avoid. Because Marcus didn't just want money, he wanted systems to change in writing. Now let's talk about what happened to Rourke. The department didn't get to hide behind training issue. They fired him. That part was already done. The next step was certification. The state standards board reviewed the referral. the internal findings, and the video. The key issue wasn't that he was rude. It was that he used police authority without lawful grounds, escalated when challenged, and refused basic identification while threatening arrest without probable cause. That's exactly the kind of conduct that certification systems are supposed to block. The result, Rourke lost his peace officer certification. No lateral transfer. No fresh start in the next county. No slipping into a smaller department that doesn't ask questions decently. Without certification, he couldn't legally serve as a sworn officer anywhere in that state. And most agencies won't touch someone with that record, even where transfers are technically possible. Career over, on paper. The department also got hit where it hurts: policy and oversight. The settlement forced reforms that weren't optional and weren't, "we'll look into it." Here's what changed because of this case. Mandatory de-escalation training for the entire force, with specific modules on lawful detention standards, not just communication. Clear stop and detain guidance, requiring officers to articulate reasonable suspicion early and document it accurately, with supervisor review triggers when detentions exceed a set time. Badge and identification compliance requirements, including discipline if an officer refuses to identify when requested during a detention. Bodycam, compliance auditing, not just body cam on, but reviewing positioning, activation timing, and whether officers are intentionally obstructing footage or manipulating the record. Supervisory response standards, meaning if a citizen requests a supervisor during a detention, it gets treated as an accountability request, not an inconvenience. Early evidence preservation protocols, because Marcus made it obvious how quickly footage goes missing when nobody locks it down immediately. And the biggest shift wasn't even the policies. It was the internal culture shock. Because officers watching that footage learned something whether they wanted to or not. You can't bluff the Constitution on camera. Not anymore. Not when the person you're stopping knows how to build a case in real time and the public knows what it's looking at. Marcus didn't do a press tour. He didn't need to. He let the results speak. Fired officer, decertified officer, settlement check, policy reforms, mandatory training, supervisor accountability, a department forced to write down rules they used to treat as suggestions. And here's the lesson that landed hardest. Technology doesn't create justice by itself. A camera alone won't stop a bad stop. What balances the scale is the mix: recording plus knowledge, oversight plus documentation, calm plus precision. That's why this officer's ego didn't just get bruised. It got audited. Now, I want to know what you would have done. Would you have stayed calm like Marcus did? Would you have asked for a supervisor? Would you have started documenting out loud for the camera? Tell me in the comments. And if you want more stories where accountability wins and the truth gets preserved in real time, like the video, subscribe to the channel, and hit the like button. It helps us keep bringing these cases to your feed.
Ma'am, I need your ID.
Sir, explain to me what's the reason you stopped me.
It's a welfare check. I need to know who you are.
I did nothing wrong, so you have no legal reason for demanding my ID.
Your vehicle matches something we're looking at.
Matches what call, what description, what incident?
Ma'am, this can go a different direction if you keep pushing.
This cop thought he was teaching a lesson to a random citizen, but he was actually walking into a legal nightmare. He came in hot, like he expected instant compliance. Then you could see it. His whole approach changed the moment he realized the woman he was pressing for ID wasn't just anyone. He demanded her identification. He wasn't prepared for her authority. Tell me where you're watching from, state or country, in the comments. And if you like stories where people stay calm, know the law, and make misconduct expensive, hit like and subscribe. These encounters happen fast. Being ready matters. Now rewind. Avery Cole pulled into a legal street parking spot near a small downtown park. Midday, people walking by, a couple benches, nothing isolated. She wasn't blocking a driveway, no fire lane, no illegal tint issues. She shut the car off and stayed inside for a few minutes, working on her phone before a meeting across the street. A patrol car rolled past slow. The officer's head turned towards her vehicle. The patrol car kept going, then looped back. Officer Grant Holloway parked behind Avery at an angle that wasn't friendly, not fully blocking her, but close enough to signal pressure. He got out right away and walked up with a fast pace and a hard posture. He didn't start with a greeting. He started with a demand for identification. Avery didn't start digging around the car. She kept her hands visible. She lowered the window slightly, enough to speak. She asked what the reason was. Specifically, what crime he suspected. Holloway didn't give a specific crime. He said the area had issues. He referenced complaints. He said she'd been sitting there too long. He repeated that he needed her ID. Avery kept her voice even. She asked if she was being detained or if this was a voluntary contact. Holloway didn't answer that directly. He repeated the demand and framed it like it was non-negotiable. He acted like refusing ID was automatically suspicious. Avery asked again if she was free to leave. Holloway changed the reason. He called it a welfare check. He said he needed to make sure she was okay, but he still kept the same demand-first approach. No, are you all right? No. Do you need help? Just ID. Avery asked, what about if her looked distressed or in danger? She was parked legally in daylight, sitting upright, phone in hand. Holloway shifted again. He said the vehicle matched a description. He didn't say what description. He didn't say what incident. He didn't give a time or a direction of travel. He stayed vague, then repeated the ID demand like the vagueness was enough. Avery didn't argue the whole world. She narrowed it back down to the law. She asked what the specific reasonable suspicion was and whether she was being detained. A woman walking a dog slowed down on the sidewalk. She looked at the officer's stance at the window and pulled out her phone. She started recording from a few yards away. Holloway noticed the phone. He didn't step away. He kept going. He tried to pull Avery into small talk questions that weren't small talk. Where she was coming from. Where she was headed. Why she was parked there. How long she'd been sitting. Each question had the same pressure behind it. Answer so he can justify the stop after. Avery didn't volunteer extra. She stated the basics. She was parked legally. She wasn't committing a crime. She repeated the question that matters. Detained or free to go? Holloway raised his voice slightly and repeated the ID demand again. He hinted at escalation. He hinted at calling backup. He framed her calm questions as making it difficult. Avery asked for his name and badge number. He gave it. She repeated it clearly so it would be captured on the recording. Then she requested his supervisor. Holloway pushed back. He said it wasn't needed. He said he could handle it. He stayed at the window, trying to keep control of the moment. Avery didn't move off it. She requested the supervisor again. Holloway started talking about people sitting in cars and what that usually means in that area. He didn't tie it to a specific report. He didn't tie it to her behavior beyond being parked. He returned to the same demand. ID. Avery gave one more clean line. If he was detaining her, he needed to state the legal basis. If he wasn't detaining her, she wasn't required to provide ID. Holloway responded by repeating the demand again. Avery waited until the pattern was clear on camera. Then she identified herself. She gave her name and her title, the district attorney for the county. You could see the shift right away. His voice changed. His posture changed. His wording changed. The demand turned into justification. The command tone turned into professional tone. He started talking like it was routine and harmless. Avery didn't match his energy. She kept hers the same. She repeated the request for a supervisor. She told him she wanted the interaction documented and the body camera preserved. Holloway stepped back from the window. The bystander kept recording. Avery stayed parked, calm, still. No shouting, no drama. Just a legal boundary drawn in plain language. Avery had said who she was. District attorney. The phone on the sidewalk kept recording. Officer Holloway stayed near the driver window, but his approach changed. Less command, more explanation. He started talking like the whole thing was routine. Avery didn't argue tone. She forced clarity. She asked one question and kept returning to it. Was she being detained? Holloway didn't give a clean yes or no. He tried to keep it in the gray zone. He kept asking for ID while avoiding the word detained. That's a common move. If he says it's voluntary, she can refuse and leave. If he says it's a detention, he needs legal grounds. Avery tightened the lane again. She said she was parked legally. She said she hadn't committed a crime. She asked him to state the specific reasonable suspicion for a detention, not the area, not complaints. A specific suspected offense tied to specific facts. Holloway offered a new reason. He referenced a description again, still vague. Avery asked what description from which call and what the reported crime was. She asked whether dispatch had broadcast anything matching her vehicle. She asked whether he ran her plate before approaching and what that return showed. Holloway avoided details and repeated the ID demand. Avery didn't raise her voice. She gave structure. She described the difference between a consensual contact and a detention in plain terms. She said he could talk to her voluntarily, but he couldn't order her to identify herself without lawful grounds. She said if he believed a crime was happening, he needed to say which crime and why. Holloway tried a pressure tactic. He framed her refusal as non-compliance. He warned her that refusing to identify could go bad. He hinted at calling more units. He said he was trying to keep it simple. Avery didn't mirror that. She asked for his supervisor again. Holloway resisted that too. He said it wasn't necessary. He said he was handling it. He tried to keep the conversation between the two of them. The bystander's camera stayed up. No yelling, no interference, just a clear record. Avery asked if his body camera was on. Holloway said it was. Avery then said she wanted the supervisor to respond to the scene, and she wanted all footage preserved. She said she was requesting it as a formal matter. That moved it from random stop to paper trail. Holloway tried another pivot. He said he was doing a welfare check. Avery asked what indicators triggered it. He didn't point to anything concrete. Avery repeated, if there was no specific reason to believe she needed assistance, then it wasn't a welfare check. It was an investigation without a stated crime. Holloway repeated the ID demand again. Avery responded by repeating the legal fork again. Either she was detained with reasonable suspicion stated on the record, or she was free to leave and didn't have to provide ID. He didn't answer directly. He changed the subject to her attitude. He said she was being difficult. He referenced cooperation, like it was a legal requirement. Avery kept it short and controlled. She said she was cooperating with lawful instructions. She said she wasn't required to surrender rights to make an officer comfortable. She asked for the supervisor again. Holloway finally stepped away a few feet and used his radio. While he did that, Avery stayed still, hands visible, no sudden movements, no searching for documents. She didn't give him a reason to claim furtive anything. The bystander kept recording from the sidewalk, capturing the patrol car angle, the officer position, and the fact Avery was simply parked. A few minutes later, a second patrol unit arrived, then a supervisor vehicle behind that. Sergeant Lena Park stepped out and walked up with a different posture, less performance, more assessment. She looked at Avery's car, then at Holloway, then at the bystander recording. Sergeant Park asked what the stop was for. Holloway tried to summarize it as a check. He referenced the area again. He referenced the description again. He said Avery refused to identify. Sergeant Park then asked the same key question Avery had been asking. What specific reasonable suspicion did he have that Avery had committed, was committing, or was about to commit a crime? Holloway didn't give a clean answer. He stayed general. Avery spoke to the supervisor the same way she'd spoken to Holloway. No insults, no heat. She stated she was parked legally. She stated the officer demanded ID without stating a crime. She stated she asked multiple times if she was detained and didn't receive a clear response. She stated she wanted the encounter documented and she wanted body cam and dispatch records preserved. Sergeant Park asked for Avery's name. Avery gave it, then repeated her title, District Attorney. Sergeant Park's face stayed controlled, but her tone sharpened in a different way, focused, procedural. She acknowledged Avery and shifted her attention back to Holloway. Sergeant Park asked for his body cam status and the call details. She asked whether he had a CAD entry. She asked what he observed before initiating contact. She asked whether he could articulate reasonable suspicion. Avery didn't add anything extra. She let the supervisor do the questioning. The sidewalk camera kept rolling, and right there, the whole scene changed from cop versus citizen to supervisor managing a liability in real time. Sergeant Lena Park stood at the driver window for a few seconds, just taking in what was on display. Patrol car angled behind a legally parked vehicle. An officer positioned like it was a stop. A bystander filming from the sidewalk. A calm driver asking basic legal questions. Park asked Avery for her name again, like she wanted it clearly stated on the record. Avery gave it. Then she restated her role. District Attorney for the county. That's when the scene tightened. Park didn't react loudly. She didn't need to. She shifted into damage control mode. Her questions turned sharper and more specific. Not emotional, procedural, focused. She asked Officer Holloway what his legal basis was for demanding ID from a person parked legally. Holloway tried to give a layered answer. He referenced the area. He referenced crime patterns. He referenced a description. He referenced welfare concerns. Park didn't accept the bundle. She separated each claim. She asked which claim happened first, what he observed before he approached, what exact facts made him believe Avery was involved in a specific crime, what report he was responding to, whether dispatch sent him to this vehicle or he chose it on his own. Holloway kept his answers general. Park kept her questions narrow. Avery stayed quiet while Park questioned him. When Avery spoke, she didn't argue feelings. She recited the sequence. Park behind her at an angle. Demand for ID. No crime stated. Multiple requests for clarification. Multiple attempts to get a yes or no on detention. Shifting reasons. Supervisor requested. Camera recording. Park asked Avery if she had been told she was free to leave. Avery said no. Park asked if Holloway told her she was being detained. Avery said no. Park asked if she had been accused of any specific offense. Avery said no. Park then asked Holloway in front of the bystander camera whether Avery was being detained. Holloway gave a reluctant answer. He tried to say it was a check. Park pushed again. Detained, yes or no? He finally said she wasn't detained. Park immediately told him to step back from the vehicle. And that's the moment everybody could see the shift. Not because of a dramatic speech, because the power moved. The supervisor took control of the scene. The officer lost the ability to keep freelancing. Avery asked Park for two things, clearly and calmly. Confirmation that she was free to leave. Confirmation that all recordings and logs would be preserved. Park said Avery was free to go. Avery didn't leave yet. She kept it professional and locked down the details. She asked Park to identify Holloway by name and badge number for the record. Park did. Avery repeated it back so the sidewalk recording captured it. Then Avery asked Park for the incident number or CAD reference for the contact. Park didn't have it on the spot. She said she'd generate it. Avery said she wanted it provided to her office that day. Not next week. Not whenever. Holloway stood off to the side, no longer talking at the window like he owned the moment. His tone had already changed once when Avery identified herself. It changed again under Park's control. He stopped giving commands. He stopped repeating the ID demand. He stopped trying to turn cooperation into a requirement. Avery addressed the biggest issue out loud, so the record didn't get rewritten later. She stated that the demand for ID came before any claim of a specific crime. She stated that the reasons changed multiple times. She stated that she was treated like a suspect without a stated basis. She stated the interaction needed review for policy and constitutional compliance. Park didn't argue with her. Park kept it in the lane of procedure. She said she'd handle it through the chain. Avery asked one more question that mattered. She asked whether Holloway's body camera had been activated before he approached the car. Park looked at Holloway and asked the same. Holloway said it was on. Avery said she wanted confirmation that it would be flagged for preservation and not overwritten. Park acknowledged that request. The bystander on the sidewalk didn't move closer, didn't interfere, just kept the phone up. That footage mattered because it showed the whole setup: the legal parking, the patrol car angle, the officer posture, the supervisor arrival, and the moment the stop dissolved after the legal authority got named. Avery then ended it clean. She said she'd be requesting dispatch logs, body cam, and any reports or notes tied to the encounter. She said her office would review it. She said she expected full cooperation. No threats, no flexing, just process. Then she left. Normal, legal, calm. And the reason this hit so hard wasn't that she was the district attorney. It was that nothing about her rights should have depended on that. By that evening, the sidewalk video wasn't just sitting on somebody's camera roll. Maya, the woman with the dog, posted it with a simple caption about a legal parking space, an ID demand, and the tone change after the title came out. She didn't edit it into a movie. She clipped it into short segments so people could see the sequence. Demand first, reasons later, supervisor arrival, then the sudden politeness. It spread fast because it was familiar. People recognized the pattern right away. The way an officer treated a calm person like a suspect without a stated crime. The way just checking turned into a pressure campaign. The way the whole thing softened only when status entered the chat. Within 24 hours, local accounts picked it up. Then community pages. Then a legal commentary channel stitched it with on-screen timestamps. And the simple question everyone asked: what was the reasonable suspicion? The department responded the way departments usually do at first. A short statement. Words like reviewing. Words like context. Nothing specific. No admission. No apology. That didn't last long because this time the person targeted wasn't stuck begging for records. Avery's office sent formal preservation requests the next morning. Bodycam, dispatch audio, CAD logs, any notes, any supervisor reports, any unit-to-unit radio traffic. She requested it as an official matter tied to an incident involving a deputy district attorney's office holder, which meant the internal handling had to be careful and documented. Internal affairs opened a case, not a "we talked to him," a real file, case number, assigned investigator. And the department had another problem: the bystander video. Because if the body cam missed the start, the sidewalk video still showed the approach, the initial demand, and the lack of a stated crime. It also captured the supervisor asking for specific facts and the officer not giving clean answers. That outside angle made it harder to reshape later. Local reporters started calling. The city council got emails. The police chief's office got requests for the stop policy and ID procedures. Community groups asked why a legal parked car triggered enforcement energy at all. Then people came forward. Well, not to talk about Avery, to talk about Officer Holloway. A string of similar stories showed up in the comments and in inboxes. Same zone, same style. A cop who treated questioning the stop as a personal challenge. Stops that started with control and ended with a vague, "be careful," after wasting someone's time. Avery didn't hold a press conference. She didn't need to. She moved like a prosecutor. Quiet, documented, immediate. Her office requested a meeting with the police chief and city legal counsel. Not a photo op. A policy meeting. She asked for 3 things. 1, the full record of the incident, unedited, with preservation confirmation. 2, Officer Halloway's complaint history and any prior supervision notes. 3, a review of how patrol officers were trained on consensual encounters, detention standards, and ID demands. The department tried to keep it narrow. 1 misunderstanding. 1 contact. That didn't hold because the video showed shifting pretexts and an ID demand without a stated crime. It also showed the moment the rules seemed to change when the title came out. People didn't miss that. A few weeks later, the consequences started stacking. Officer Halloway got pulled off patrol pending investigation. Desk duty. No proactive stops. No field discretion without oversight. Internal Affairs interviewed the supervisor and reviewed the logs. They checked whether he created a CAD entry after the fact, whether he had any dispatch basis for the description claim, and whether policy required a reason before demanding ID. The department issued a training memo. It focused on reasonable, articulable suspicion, the limits of welfare checks, and how to handle consensual encounters without turning them into detentions. Not a vague memo. A reminder tied to real discipline risk. Then came the part officers hate most. Documentation that sticks. The department added the incident to their early warning tracking for repeat complaints. That meant every future complaint hit heavier. It also meant supervisors had to sign off on certain actions. More oversight, less freelancing. Avery also made sure the community understood the actual lesson, because the headline wasn't, DA gets harassed. The headline was, this is what happens to regular people when nobody important is sitting in that seat. So she did something strategic. She partnered with a local legal clinic and recorded a short rights education segment for the county site. Simple language, no legal flexing, just practical steps. Ask if you're being detained. Ask what crime is suspected. Keep your hands visible. Don't reach around the car. Record if it's legal in your state. Stay calm and repeat your question. Get names and badge numbers when you can. Ask for a supervisor if the encounter turns into pressure without explanation. She also emphasized a point people avoid. Filming isn't about winning. It's about accuracy. It stops the story from changing later. As for Halloway, the outcome didn't end with a dramatic firing announcement on TV. Real accountability usually looks less cinematic and more administrative. The investigation resulted in documented policy violations. The department imposed discipline. His ability to initiate discretionary contacts got restricted. His evaluations changed. Future promotions got complicated. His supervisors now had a paper trail that followed him. And the community got something rare. Proof on video of how quickly authority becomes negotiation when the person in the car has power back. Avery never celebrated it like a win. She treated it like a warning sign with a receipt. Because the point wasn't that she could defend herself. The point was that she shouldn't have needed a title for the law to apply. So, here's the question for you. If you were sitting in that car, calm, legal, and respectful, would you have known what to ask? Would you have recorded? Would you have stayed steady when the pressure started? Drop your thoughts in the comments. Share this with someone who needs it. And if you want more stories like this, realistic, modern, and focused on accountability, make sure you're subscribed because more are coming.
Hey, hold up a second. You live around here?
What's this about, officer?
Who's the kid with? That your child?
Yes. What's the reason you're asking?
All right, I need to see your ID.
There's no legal basis for that.
It's weird. You're out here with a stroller. Maybe the child is not yours.
If you have any questions about my child, say it plainly and tell me what facts you have.
This officer thought he was detaining just another civilian for a routine stop, but he had no idea he was actually interrogating a powerful federal judge. Watch as the tables turn the second the man with the stroller stops playing friendly and starts demanding the one thing that matters: articulable, reasonable suspicion. The officer tried to bluff his way through it. He couldn't. And by the time the truth came out, this wasn't a routine stop anymore. It was a public lesson in legal accountability that the officer couldn't talk his way out of. Where are you watching from? Country, state, city? Drop it in the comments. And if you like stories where people stay calm, know their rights, and make power answer for itself, hit like and subscribe. These situations don't change unless people understand what's allowed and what isn't. Now, rewind. It was a normal afternoon in a quiet neighborhood near a small park. Sidewalk traffic, parents, dog walkers. Nothing that screamed danger. The kind of place where people claim they want safety, but what they really mean is control over who looks like they belong. Julian Wells had left his home for a quick walk with his toddler in a stroller. He looked like what he was, a father doing a routine thing. No drama, no urgency. He moved at stroller pace, slow, predictable. A neighbor saw him and didn't see Dad. They saw a problem. They made a call, not about a crime, not about a specific act, just a label that's been used forever because it's vague enough to work. Suspicious person. Officer Trent Harlow responded like the label was proof. He pulled up fast, got out fast, and walked straight into Julian's path instead of approaching like this was a check-in. His posture did the talking. He wanted Julian stopped before he even knew what was being alleged. Harlow started with demands, identity, address, reason for being there. Then he stacked the questions that always show what the stop is really about, where the child's mother was. Whether the child was his, why he didn't look familiar, the same old move. Make a normal situation sound abnormal, then treat confusion as guilt. Julian didn't escalate. He didn't perform. He didn't try to charm his way out either. He kept one hand on the stroller handle and kept his other hand visible. Calm face, calm voice. The kind of calm that doesn't read as fear, it reads as control. That calm annoyed Harlow. Because Harlow wanted compliance, immediate, automatic, grateful compliance. Julian gave him something else. Structure. Julian asked a basic question that forces a cop to commit. Was this a consensual conversation or a detention? Was he free to keep walking or not? He didn't say it like a challenge. He said it like he needed clarity for the record. Harlow tried the middle lane, not calling it a detention, but also not letting Julian leave. That gray zone cops use when they don't have enough to stop you legally, but don't want to give up the stop. Julian didn't accept the gray zone. He asked what specific facts created reasonable suspicion. Not a vibe, not a call. Facts that could be written down and defended. He kept it tight. No speeches, just the legal threshold. Harlow's answer shifted. First it was a report, then it was recent incidents. Then it was, you match a description, without giving a description that meant anything. He kept moving the goalposts because he was fishing. Julian noticed every shift. This is where the power chess started. Julian signaled that he was documenting the interaction. He didn't wave the phone around. He didn't get theatrical. He just made it clear this encounter had a record now, and that the record would outlive whatever story the officer tried to build in the moment. Harlow's tone tightened again. His body angle changed. He stepped closer to the stroller like proximity itself was a tool. He kept talking like Julian owed him answers just because he was wearing a uniform, but Julian stayed in one lane, legality. He asked for the officer's name and badge number. He asked whether Harlow was ordering him to provide ID or requesting it. He kept forcing the officer to choose words carefully. That's what people don't realize. A stop lives and dies on language. When an officer gets sloppy, the whole thing collapses later. Harlow got sloppy. He treated Julian like refusing to chat was the same as doing something wrong. He implied that Julian was making it harder than it needed to be. That line always shows up when the officer doesn't have enough. It's pressure, not law. Julian didn't argue feelings. He didn't debate respect. He went straight back to the standard. What crime did the officer suspect? and what facts supported that suspicion. On the sidewalk, a couple people started paying attention. Not a crowd, just enough. A jogger slowed down. Someone across the street lifted a phone, not hiding it. That matters. Officers act different when they know the public can replay their choices. Harlow noticed the attention and tried to lock the scene down. He shifted from questions to instructions. He wanted Julian to stay put. He wanted control back. And that's when Julian made the quiet pivot that changed everything. He stopped engaging like a regular person trying to get through it. He started engaging like someone who'd spent years watching unlawful stops get justified after the fact. He called out the exact legal problem in real time. No clear reasonable suspicion, no lawful basis to prolong, no authority to treat a father with a stroller like a suspect because a stranger felt uncomfortable. Harlow still didn't know who Julian was. He just knew he wasn't getting the easy win. And the longer he stayed there without a solid reason, the worse it got for him. Officer Trent Harlow realized fast that Julian wasn't going to talk himself into trouble. No rambling, no nervous explanations, no apologizing for being outside. Julian kept the stroller still, kept his hands visible, and kept steering the interaction back to one issue: whether the officer had a legal reason to stop him. Harlow responded the way a lot of officers respond when they don't like that kind of calm. He tried to make the stop feel unavoidable. He said he was responding to a suspicious person call and treated that label like it automatically gave him authority. He didn't describe a crime. He didn't describe a specific action. He just kept leaning on the fact that someone called. Then he pushed for ID again. He didn't ask like it was optional. He asked like refusal would become the reason for the stop. Julian didn't hand anything over. He asked a clarifying question through the narrator's reporting, whether this was a voluntary contact or an actual detention. He needed the officer to pick one. Harlow tried to stay in the gray area. He kept Julian in place while refusing to say exactly what Julian was suspected of doing. That gray area is where a lot of bad stops live. If the person stays, the officer claims cooperation. If the person leaves, the officer claims flight. Either way, the officer keeps control. Julian didn't let the officer have that. Harlow changed angles and focused on the stroller. He looked down at the toddler, then back at Julian, and started asking questions about the child. Who the child was, where the child's mother was, whether Julian could prove he was the father. He framed it like concern, but it landed like suspicion. The questions weren't about safety. They were about forcing Julian to justify his family on a sidewalk. Julian kept his voice even. He didn't get loud. He didn't insult the officer. He asked for the legal basis again, this time tied directly to the new line of questioning. If the officer was suggesting something involving the child, he needed to state what he suspected and what facts supported it. Harlow couldn't support it, so he started cycling through new reasons. He referenced vague neighborhood complaints. He mentioned recent incidents without naming one. He hinted at kidnapping without saying it plainly. He suggested trespassing even though Julian was on a public sidewalk. Each explanation wasn't building into a coherent story. They replaced each other, depending on what sounded most serious in the moment. A jogger slowed down on the opposite side of the street. Someone on a porch stopped and watched. Another person raised a phone and recorded openly. Harlow noticed. His eyes kept flicking toward the cameras. His tone tightened. He tried to take control of the physical space. He stepped closer than he needed to. He angled his body so Julian had less room to move the stroller forward. He asked Julian to step away from the stroller for safety. That request wasn't neutral. If Julian stepped away, Harlow controlled the child's space and could reshape the scene however he wanted. If Julian refused, Harlow could label it non-compliance. Julian didn't step away. He stayed beside the stroller and kept his posture neutral. He made sure his hands stayed visible. He didn't give Harlow a reason to claim fear. He also didn't give Harlow control over the stroller. Harlow pressed again for ID and started narrating Julian's behavior like he was writing a report out loud. He described Julian as uncooperative. He implied Julian was causing the situation. That's another tactic. If the officer says it on scene, he hopes the person reacts and gives him something on camera that can be used later. Julian didn't react. He asked for the officer's name and badge number. He asked for a supervisor. He made it clear he would not consent to searches and would not answer investigative questions without a lawful basis for detention. He kept it procedural and calm, the way someone talks when they expect oversight. Harlow tried a pressure move that went beyond the stop. He implied that refusing to cooperate could lead to bigger problems. He hinted at taking Julian in to sort it out. He hinted at involving child services. He didn't state a charge. He didn't give a clear legal reason. He just tried to scare compliance out of Julian. That was when the bias showed itself more clearly. Harlow talked about the neighborhood like Julian didn't belong in it. He treated Julian's presence as suspicious by default, not because of anything Julian did, but because Julian didn't match the officer's mental picture of who belongs in that area. The stop stopped being about a call. It became about assumptions. Julian didn't turn it into a street argument about race. He treated it like a legal problem with a paper trail. He asked again for the specific facts that created reasonable suspicion. He repeated the supervisor request. He indicated that the encounter was being recorded and that he wanted the incident documented by name and badge number, not left as an informal stop that disappears. Harlow radioed for a supervisor. While they waited, the tension stayed in the air. Harlow kept his stance squared up like he couldn't afford to look wrong in front of the people watching. Julian stayed with the stroller, calm and still, like he understood that the safest move was to keep everything boring, visible, and recorded. And Julian made a choice that was going to change the rest of the interaction. He didn't announce it. He didn't posture. He reached for something in a controlled way, explained what he was doing before he did it, and prepared to show documentation that would force the conversation out of Harlow's emotions and into a world Harlow couldn't bluff his way through. The supervisor was still a few minutes out, and Officer Harlow was trying to hold the scene together long enough to look like he had control. He kept Julian in place without clearly saying he was detained. He kept asking questions that had nothing to do with a specific crime. He kept scanning around at the people watching and recording. Julian didn't let the officer's mood set the pace. He stayed beside the stroller. He moved carefully. He explained his movements before making them, because he wasn't giving Harlow any excuse to claim fear. He reached into his jacket pocket slowly and pulled out a wallet. He didn't flash anything like he was trying to win a flex contest. He held it in a way that made it easy for the officer's body camera to capture. He gave Harlow the minimum needed to understand what was happening. It was official federal judiciary identification. Harlow's face changed immediately. His voice lowered, his shoulders dropped, his eyes went back to the credential more than once, like his brain was reloading the whole situation. A second ago, he had been treating Julian like a problem to manage. Now he was standing in front of someone who could turn this sidewalk stop into a documented legal issue that wouldn't stay inside the department. Harlow tried to recover fast. He shifted into politeness. He started acting like this had been a simple misunderstanding and he was ready to clear it up. He tried to move the moment along like the last several minutes hadn't happened. He tried to reframe himself as cautious, professional, doing his job. Julian didn't accept that rewrite. He didn't raise his voice. He didn't threaten the officer. He did something that hit harder than emotion. He explained exactly why the stop was unlawful and why the officer's apology wouldn't fix the damage. He pointed out the basic issue. Harlow had treated a vague call as enough to stop a person. Then, when questioned, he kept changing the suspected offense instead of stating one clear reason supported by facts. He also tried to escalate through intimidation and control instead of legal justification. And he aimed suspicion at Julian's parenting without any evidence. A child was involved, and that made the officer's choices more serious, not less. Harlow tried to interrupt. He tried to say he had to respond to calls. He tried to make it about procedure and safety. Julian kept it tight and direct. Responding to a call didn't mean detaining someone without reasonable suspicion. Feeling uncertain didn't create lawful authority. If Harlow couldn't articulate a specific crime and specific facts, the stop should have ended early. Instead, he prolonged it and pushed it into something it never needed to become. Then the supervisor arrived. Sergeant Alvarez pulled up, stepped out, and read the scene in about 2 seconds. Stroller, dad. Officer squared up, bystanders filming. That alone told her this was already a problem. Then she looked at Julian and caught the name. She didn't overreact. She didn't put on a show. Her posture shifted just slightly, the way people do when they realize they're standing in front of someone with real institutional power. She spoke with controlled professionalism and asked what happened. Harlow started talking immediately. He tried to get his version in first. He framed it like a routine check based on a call and implied Julian had been difficult. Alvarez didn't ignore him, but she didn't let him dominate. She asked one question that matters in every stop review. What facts created reasonable suspicion? Harlow gave the same vague answers he had been giving on the sidewalk. Call, concerns, recent issues, matching description, nothing clean, nothing concrete. Julian stayed calm and made the timeline simple for the supervisor. The stop started with a vague label. It grew into an ID demand without a stated offense. Then it shifted into questions about the child without evidence. Then it included threats and pressure to comply. Then it only cooled down after Harlow saw federal credentials. Alvarez understood what that meant. Even if she wanted to protect her officer, she couldn't protect that sequence if there was body camera footage and public video. Harlow tried the quick exit. He aimed for the easiest resolution. Let Julian go, apologize, and end it before it became a formal complaint. He tried to make it sound like everyone could just move on. Julian didn't let it stay informal. He told the supervisor he wanted the incident documented. He wanted the incident number. He wanted confirmation that body camera footage would be retained. He wanted the names and badge numbers recorded in writing. He also wanted a clear explanation of how suspicious person calls were being used in that neighborhood, because this stop followed a pattern that wasn't about safety. It was about who looked acceptable on a sidewalk. Alvarez tried to keep it calm and contained. She offered to talk off to the side. Julian stayed where the cameras could see. That wasn't for drama. That was for accountability. Private conversations disappear. Public records don't. Alvarez gave Julian the incident information and confirmed she would initiate review. She also directed Harlow to step back. That instruction wasn't loud, but it was firm. Harlow obeyed it instantly. A minute ago, he had been demanding compliance from Julian. Now he was taking commands and trying not to be seen as the reason this was about to blow up. Julian didn't gloat. He didn't embarrass him for sport. He made the point clearly because that was the real lesson of the moment. Authority without legal basis turns into harassment fast, and the public shouldn't need a federal title to be treated lawfully. Julian then ended the sidewalk part of it the same way he started it. Calm, controlled. He made sure the supervisor had what she needed to document the stop. He ensured the stroller was never out of his reach. Then he continued his walk, not because the officer allowed it, but because the detention had no lawful foundation to begin with. The video spread that same night. 2 angles. Calm father with a stroller asking for the legal basis. Officer escalating without stating a clear crime. By morning, complaints hit the department. Civil rights groups asked for body cam footage, and reporters started calling. Then Julian's name got confirmed. people realized the random dad was a federal judge. That changed the whole conversation. If this happened to him, it was happening to everyone else who didn't have status. Internal affairs moved fast. They pulled dispatch logs, CAD notes, Bodycam, and witness video. The review focused on basics: no clear, reasonable suspicion, shifting explanations, prolonged stop, and questioning the child's parentage without evidence. Officer Harlow got taken off patrol during the investigation. The department later sustained policy violations and disciplined him, with a serious suspension and mandatory retraining, plus a formal warning tied to escalation during a stop involving a child. They also reviewed whether he had a pattern of similar stops. Julian didn't accept a quiet apology. He pushed for changes. Clearer rules for suspicious person calls, required documentation of reasonable suspicion for pedestrian stops, stronger supervisor review, and body cam retention that couldn't be quietly trimmed. The bigger point stuck with the community. Constitutional rights shouldn't work only when the person stopped has a title. People started recording more, requesting supervisors more, and pushing the city to track stops and publish the data. So what would you have done in his place? Stay procedural or try to talk your way out? Comment your take, share this with someone who needs it, and subscribe for more stories where calm beats control and accountability actually lands.
Hey, what's going on here? Let me see your IDs.
What's the reason we need our IDs?
We got a call. Two suspicious people hanging around.
Call for what exactly?
Just handle it. Show me ID and we're done.
No, you need to state a clear reason with facts.
This area's had issues. People casing places. You two look like you're watching.
Watching what?
What happened when a Riverside County patrol officer decided two black professionals eating lunch didn't fit the neighborhood and tried to turn a normal cafe table into a criminal investigation? The answer wasn't some messy argument. It was worse, because the officer didn't just pressure them for ID. He built a false story on the radio, and the recording caught every step of it. Quick question before we jump in. Where are you watching from? Drop your city or state in the comments. And if you're into stories where calm people don't get bullied and the truth actually sticks because someone hits record, tap like and subscribe. These cases don't go viral by magic. They go viral because receipts exist. So here's the moment it started going sideways. Officer Grant Holloway walked up like he already had the ending in his head. Adrian Brooks and Nicole Brooks sat at an outdoor cafe table, plates pushed aside, both reading. No raised voices, no crowd, just two people finishing lunch in public-facing seating that belonged to the cafe. Holloway didn't ask if everything was okay. He didn't start with basic courtesy. He started with control. He told them he'd gotten a call about two individuals hanging around. Vague, no description of a crime, no mention of a victim. Just that tone cops use when they want you to stop being a person and start being a situation. Then he pushed for ID. Not a request like, hey, mind if I see it? It came out like a demand, like they owed him paperwork for sitting in a chair they were paying to sit in. Adrian didn't get loud. He didn't perform. He stayed seated. He asked the clean question that always matters. What's the legal reason for this? Were they being detained? What crime was being investigated? Holloway didn't answer straight. He circled. He kept leaning on the call. He kept implying the area had standards and they weren't matching them. That little unspoken message. You know it. You're here, but you're not the kind of people who are supposed to be here. Nicole stayed calm too. She didn't argue feelings. She didn't lecture. She did something smarter. She started recording audio. Not in a dramatic way. No announcement. Just quiet documentation, while she asked simple questions that forced Holloway to either articulate a lawful basis or expose that he didn't have one. He responded by escalating the story. He said he believed they were casing nearby businesses and homes, said their reading was an act, said the couple vibe was cover, like two adults at lunch was some kind of con. And once he said that out loud, he tried to make it real with threats. He brought up loitering, then trespassing. Even though they were sitting at a cafe table that was literally placed outside to be used by customers, even though staff hadn't complained, even though no one at the cafe had asked them to leave. That didn't slow him down. It fueled him. This is how these stops turn into traps. The officer doesn't need facts first. He just needs you to flinch. He needs you to get nervous, get angry, stand up too fast, say the wrong thing, anything he can label as non-compliant after he's already decided you're suspicious. But Adrian and Nicole didn't give him that. They stayed seated. They kept their voices even. They kept their questions short and specific. What was the call exactly? What was the alleged crime? What behavior specifically looked like casing? Did he have a complainant? Had anyone from the cafe reported them? Holloway avoided the questions. He returned to the same vague statements. He tried to pull them into a conversation where he was the only one setting rules. He wanted them explaining themselves. He wanted them volunteering details. He wanted to fish. Nicole didn't bite. She let him talk. Let him fill the space. Let him stack assumption on top of assumption. Then Holloway took the step that changed everything. He keyed his radio and called for backup. And he didn't call it in like a normal public contact check. He upgraded the language. He framed it like a dangerous, suspicious person situation. He made it sound like he'd stumbled onto something bigger. Then he added the word that always poisons the record. Narcotics. Possible narcotics involvement. That's what he put on the air. No drug scene, no smell, no paraphernalia, no observed transaction. Just a label tossed into the system because labels stick. That radio call mattered more than whatever he said at the table. Because now it wasn't just one officer acting up. Now it was documented, time-stamped, logged, reasonable suspicion on paper, even if it was built from nothing. Nicole heard it. Adrian heard it. And you could almost feel the calculation shift. Because once an officer starts manufacturing allegations on the radio, the danger isn't just embarrassment. It's what comes next. A search. Hands on someone. A detention that turns into an arrest because someone decided to defend their pride. Holloway stood there like he'd just tightened the net, like backup was going to arrive and make the pressure work. Adrian didn't move. Nicole didn't move. Nicole kept recording. Holloway tried again with the ID angle, leaning harder now, acting like the radio call gave him authority he didn't have 5 minutes ago. He kept implying that cooperating would make it easier. The classic line. Give me what I want and I'll stop bothering you. But Adrian kept it tight. He didn't negotiate rights. He didn't plead. He kept returning to the same point. What's the lawful basis? And Holloway kept failing to answer. Minutes later, the backup car pulled in. Officer Elena Park stepped out, walked up, and immediately read the scene the way a competent officer does. Two people seated, calm, not matching the narcotics drama that was just broadcast. Park didn't mirror Holloway's energy. She didn't jump in barking orders. She looked at Holloway, then looked at the table, then looked back at him like she wanted one thing. Facts. And right as she started pressing him for the actual reason for the stop, what crime, what evidence, what complaint, Holloway realized he wasn't the only one being recorded anymore. Because now there was a witness in uniform. Backup didn't arrive like a movie. No lights, no yelling, just Officer Elena Park, stepping into the space and taking one look at the tone Holloway had created. She didn't start by demanding anything from Adrian and Nicole. That was the first difference. She started by checking the foundation. She asked Holloway what the call actually said, what he'd observed, and what specific crime he believed was happening. Holloway tried to give her the same vague stuff he'd been using at the table. Two people hanging around, not from the area, acting suspicious. He leaned into the casing story again, said they were watching storefronts in nearby homes. Park didn't accept it as is. She asked what behavior specifically looked like casing. What did they do besides sit and read? Did he see them approach doors? Did he see them test handles? Did he see them take photos? Did any business owner complain? Did cafe staff call? Holloway didn't have any of that. So he pivoted to ID, like identification would become the evidence he didn't have. He framed it like a simple request, but his tone stayed loaded, like refusal would prove guilt. Park asked the question that forces honesty. Were they detained, or was this voluntary contact? That's where Holloway started getting sharper. He didn't like being boxed in by policy. He tried to keep it squishy. He talked around it. He hinted at detention without saying detention. He wanted compliance without responsibility. Nicole didn't argue with him. She just kept doing what had worked from the start. Calm questions, clean phrasing, no extra emotion for him to grab. She asked Park in the same steady tone what the legal basis was for ID. She pointed out they were patrons seated at a cafe, not interfering with anyone. She didn't say it like a speech, she said it like a fact. Park glanced at the table, plates, receipts, reading material, then back to Holloway. You could tell she was comparing what she saw to what she heard over the radio. And that radio call started to matter right here. Park asked Holloway why he had broadcast possible narcotics involvement. That question hit different, because it wasn't coming from a civilian. It was coming from another officer, who now had her name tied to the response. Holloway tried to justify it with pure fog. He suggested it happens in the area, implied it was part of being cautious, hinted at behavioral indicators without naming one. He couldn't point to anything concrete because there was nothing concrete. Park didn't mirror his confidence. She looked irritated, not dramatic, just that professional kind of irritation, like someone watching a coworker create a mess and expecting everyone else to mop it up. She asked him again what he actually had. Holloway then tried a different angle. He started talking about loitering and trespassing again, like those words would scare Adrian and Nicole into handing over ID just to get the moment over with. Nicole corrected the record calmly. They were customers. It was cafe seating. Trespassing didn't even make sense, unless the business told them to leave. Park asked Holloway if the cafe had requested removal. He didn't answer cleanly. Adrian stayed composed the whole time. No sudden movements, no big statements. He watched Holloway the way you watch someone who's trying to improvise lies in real time. He let Park do her job because Park was doing what Holloway refused to do, anchor the situation to reality. And you could feel Holloway trying to regain control. He shifted his stance closer to the table again. He tried to talk over Park. He repeated the demand for ID. He spoke like he was the lead, like backup was there to support his version, not question it. Park didn't let him run the scene unchecked. She asked Adrian and Nicole if they felt safe. She asked if Holloway had explained what crime they were suspected of. She asked if they wanted a supervisor. That's when the power balance tilted. Hard. Because Holloway had been acting like he was untouchable. Like he could say, suspicious, and make it true. Like he could toss narcotics on the radio and nobody would challenge it. Park was challenging it, on the record, in front of witnesses, in front of a couple he'd already tried to bully. Nicole kept recording. Holloway didn't know that for sure, but you could tell he suspected it now. His sentences got shorter. He started choosing words more carefully. Too late. Then Adrian and Nicole exchanged a quick look. Not dramatic. Just the silent kind of coordination people have when they've been trained to stay calm under pressure. Adrian reached into his wallet. Holloway leaned in like he'd finally won something, like the ID was the prize. Adrian didn't hand over a driver's license. He presented federal credentials, and the entire atmosphere changed in 1 second. Park's posture shifted immediately. She went from trying to understand to locking in. She looked at the credentials, then at Adrian, then at Nicole. Nicole followed with her own credentials. Different division, different focus, civil rights. Holloway's face changed. That confident edge dropped off him like a coat. His voice softened, then got weirdly polite. The same guy who had been throwing around arrest threats suddenly started acting like this was all a misunderstanding. Nicole made it clear this encounter had been recorded from the start. No threats, no yelling, just that clean statement that lets someone know the game is over. Holloway tried to walk it back fast. He started talking about protocol, community complaints, just doing his job. He tried to reframe it as a normal check. He tried to pretend the narcotics broadcast hadn't happened. Park didn't play along. She asked him in plain language why he escalated to narcotics with no evidence. She asked him what he planned to do if they'd handed over ID and it didn't match his assumptions. She asked what his next step would have been. Holloway didn't have answers that sounded good out loud. Not with a witness officer standing there. Not with 2 federal agents sitting at the table. Not with a recording running. So he did what officers like him do when the script collapses. He asked for a supervisor. But at this point, that wasn't him taking control. That was him trying to get cover. Park radioed for a supervisor too, and the difference in her tone mattered. She didn't sound alarmist. She sounded precise, like she wanted the chain of command involved because this had already crossed a line. And while they waited, Holloway stood there trapped between 2 realities. The one he tried to create over the radio, where Adrian and Nicole were suspicious criminals, and the real one, where they were calm, documented, credentialed, and about to turn this entire encounter into a formal problem. Because now it wasn't 2 individuals hanging around. Now it was an officer who tried to manufacture a case in public, and the wrong couple heard him do it. The supervisor arrived fast. Not because the call sounded urgent, because Park's tone sounded careful. The kind of careful that tells command staff, there's a liability problem walking around in daylight. A watch sergeant stepped up first, eyes doing that quick scan. 2 civilians seated calmly, 2 officers standing, a cafe full of people pretending not to watch, while absolutely watching. The sergeant asked Holloway what happened. Holloway gave the cleanest version he could manage. He leaned hard on a call came in. He said he approached to check it out. He claimed he tried to identify them and they refused. He floated the casing angle again, softer now, less confident, like he knew it sounded thin. Then the sergeant asked Park. Park didn't sugarcoat it. She said she arrived, saw no crime, and couldn't get Holloway to articulate reasonable suspicion. She brought up the narcotics language on the radio and said she didn't see anything that matched that claim. That detail landed. You could see it on the sergeant's face, because now it wasn't just about manners. It was about what got broadcast into the system. Adrian and Nicole stayed seated through all of it. No posturing, no gotcha energy, just calm and clear. They identified themselves again, explained they were off duty and eating lunch, and pointed out that Holloway escalated without a lawful basis. Nicole told the sergeant she had an audio recording of the entire contact from the start. She didn't weaponize it. She stated it like a fact that needed to be logged. The sergeant asked if they were willing to share it. Nicole said yes, and also made it clear she wanted the request and transfer documented properly. Chain of custody language. The kind of language that tells a supervisor right away that this isn't going away with an apology and a handshake. The sergeant pulled Holloway aside a few steps, not far. Still in view. Still public. Holloway's body language changed again. Smaller, less aggressive. He started talking with his hands like he was explaining a misunderstanding. You could tell he was trying to frame it as standard policing that got misread. Park didn't leave him room for that. She stayed close and stayed factual. She didn't attack him personally. She kept it about the missing pieces. No complainant, no observed crime, no lawful detention basis, and a narcotics implication placed into the record with nothing behind it. The sergeant asked Holloway a simple question that matters more than anything else. What was the plan if Adrian and Nicole had handed over their IDs? Holloway didn't have a clean answer, because the plan wasn't about a specific crime. The plan was pressure. The plan was hoping something popped. The plan was forcing control and calling it policing. The sergeant's tone shifted. He stopped treating it like a confusing call. He treated it like an incident. He told Holloway to step back and stop engaging. Then he spoke directly to Adrian and Nicole in a more professional, restrained voice. He apologized for the disruption. He said he'd document the interaction and requested the recording through the proper channel. He asked if they wanted medical attention, anything like that. Standard damage control script. But you could tell he meant the document part, because he had to. This was now a recorded contact with federal agents. It involved threats of arrest and escalation language on the radio. You don't bury that. You can't. Nicole didn't threaten. She didn't talk about lawsuits at the table. She didn't need to. She said they would be making a formal report. She said they'd request all related dispatch and CAD logs, radio traffic, and Bodycam footage. She also said the narcotics implication needed immediate review because it wasn't supported by anything observable. The sergeant nodded. He didn't argue. That's how you know it's serious. When the supervisor stops debating and starts managing. Before they left, Adrian asked one final clarifying question, again calm, again precise. Were they free to go? The sergeant said yes. Adrian and Nicole stood up, gathered their things, and walked out like normal people. No victory speech, no staring contest. They didn't need the cafe to clap for them. The win wasn't the moment. The win was the record. Because what happened next wasn't loud. It was a procedural. And it moved fast. Within days, the internal review started. Holloway's dispatch history got pulled. Prior suspicious person calls, prior check IDs contacts, any pattern of escalating language, any pattern of vague calls turning into fishing expeditions. Supervisors don't like surprises. And this one came with federal attention attached. Nicole's side didn't treat it like a one-off. She treated it like a data point, a potential pattern. She requested the radio traffic and the call notes that used the narcotics wording. She requested Holloway's reports. She requested training records. She requested any prior complaints with similar themes. And Park became a key witness whether she wanted that or not. She was the officer on scene who challenged the basis and questioned the escalation. Her account didn't need drama. It just needed to be consistent. It was. Holloway got pulled from the street pending review. At minimum, he didn't get to keep freelancing contacts the same way while an investigation ran. That decision didn't require a public announcement. Departments do it quietly all the time. The point is, the shift happened. Immediately. The department also had another problem. That narcotics language on the radio. It wasn't a private thought. It was an official broadcast that could have justified a search or a detention if the wrong officer heard it and ran with it. Supervisors hate that because it's how departments end up paying big money and losing public trust at the same time. So training memos started circulating. Reminders about articulating reasonable suspicion, reminders about not inflating calls, reminders about how a call came in doesn't replace legal standards. Was it because they suddenly grew a conscience? No. It was because the facts were ugly and recorded. Adrian and Nicole didn't turn it into a social media spectacle. They didn't have to. They routed it through channels that actually force outcomes. Internal investigations, records requests, oversight, and federal review. That's the part people miss. Accountability doesn't always look like a viral clip. Sometimes it looks like someone calmly gathering evidence and letting the system deal with what it can't defend. In Holloway, he learned the worst lesson a bully cop can learn. The person you're trying to embarrass might be the person who understands the rules better than you do, and they might be recording while you talk yourself into a corner. So let me ask you, if you were Adrian or Nicole, would you have stayed seated and kept it calm? Or would you have walked away the second he got weird? And if you've ever had someone treat your normal presence like a threat, what did you do? Drop your thoughts in the comments, share this with someone who needs to hear it, And subscribe if you want more real modern stories where receipts beat intimidation every time.